Welcome to Ask an Attorney, Florida Elder Law and Medicaid Planning.
Welcome to Ask an Attorney, Florida Elder Law and Medicaid Planning. John Frazier of Pippin Law Group, PLLC. John Frazier is a Florida Elder Law and Medicaid Planning attorney based in Largo, with advanced degrees in business and tax law and experience helping more than 3,500 families secure long-term care coverage. His practice focuses on almost exclusively on protecting assets and helping clients qualify for Medicaid benefits the right way. I'm Evan Mack, and today we're addressing one of the biggest fears families have, whether needing nursing home care means losing everything they've worked for. Mr. Frazier, welcome, sir.
Well, welcome, and thank you for having me this morning.
Absolutely. So, John, when someone is told they may need nursing home care, where does the fear of losing everything usually come from?
Well, I think this concept of the spend down is what creates the biggest fear. Some people have only heard about the $2,000 asset limit, and I've actually had clients begin spending that money even when they were married and one spouse still living in the community. And the asset limit is actually significantly higher for the spouse still living in the community. It's actually $162,660. So the families will hear something from a neighbor, a friend, and then they'll start doing their own Medicaid planning. And I actually had that situation where they thought it was $2,000 for both spouses, and that was completely incorrect.
So in Florida, what does Medicaid usually require someone to spend down before qualifying for nursing home coverage?
Well, there are asset limits, but there are legal ways to get around those asset limits. So the basic asset limits here in Florida, the house is exempt up to $752,000. If a spouse or a minor child is living there, there's no limit on the house. One automobile is exempt. If you have an unmarried Medicaid applicant, it's a $2,000 asset limit. If you have a married Medicaid applicant, it's $2,000 for the Medicaid applicant. And for the spouse living in the community, $162,660. If both the spouses are applying for Medicaid, it's $3,000. But we have numerous ways that we can deal with extra assets depending on what the situation is.
What types of assets are typically considered countable? Which ones are usually protected under Florida Medicaid rules?
Well, the homestead is going to be exempt, one automobile, and then extra automobiles, 7 years old or older, and not luxury vehicles. Also, IRAs and 401ks are typically going to be exempt if you set up the correct payout. Then we have countable assets, bank accounts, investments, stocks, bonds, things like that, the financial assets.
So John, how does the primary residence factor into Medicaid eligibility if someone enters into a nursing home?
It's usually a non-issue. As long as the person has lived in the homestead, it's treated as an exempt asset up to, as I said, $752,000. And the state of Florida presumes that the Medicaid applicant is going to have an intent to return home. So as long as it's less than $752,000 for an unmarried person, it's going to be an exempt asset, and it doesn't play into the Medicaid case at all. And we don't do anything with it. We just verify it, property tax bill, and the deed to the property.
How are married couples treated differently under Florida Medicaid rules when only one spouse needs nursing home care?
Well, there's a lot of differences. So if you have one spouse applying for Medicaid and the other spouse in the community, what we do is we typically move the financial assets, everything but about $1,500 over into the community spouse's name. And then once we have the Medicaid applicant to less than $2,000, then we see where the community spouse is. And many of our community spouses will have like $200,000, $300,000, $400,000, possibly more. My biggest case was actually $3.7 million. And we actually got the Medicaid applicant on Medicaid. And we used a strategy in that case called spousal refusal. And so there really is no limit if you use the spousal refusal strategy, but that's only applies to a married couple.
So can assets still be protected if planning starts after someone has already entered the nursing home?
Oh, absolutely. My typical client actually is already needs Medicaid when we're contacted. So that's actually my typical client. Here in Florida, we've got some very beneficial rules. I think the main concern is the 5-year look back to non-spouses. There's a transfer penalty to non-spouses, so no penalty between spouses, but there is generally a penalty to other people unless you have an adult disabled child disabled under Social Security. So I think moving the assets around to non-spouses is a big problem potentially.
Mm. So Florida has that 5-year look back period. What does that rule actually mean? How does that affect families who have made, gifts or those transfers you were talking about?
The state of Florida presumes that the transfer was done for Medicaid purposes, even though it may not have been done for Medicaid purposes. So technically, it's a problem. Any gift within 5 years, I think the state of Florida will make exceptions for smaller birthday gifts and things like that. But I think the closer that you get to the Medicaid application date and the bigger the transfer, that's really something that you got to be very careful about. And I think clients are just not very well versed on that issue.
Mm. Can you share an example of a situation where a family believed everything would be lost, but proper planning changed the outcome?
Well, I think the example of a married couple thinking there's a $2,000 asset limit for both of them, I think that's where everything could be lost. Had another situation where both spouses were in the nursing facility for many, many years. I guess they had $1 million or so to start out with, and they had spent about 10 years in the nursing facility. And then they came to me after they had spent nearly all that money, and there was only $50,000 left. I was able to protect the $50,000, but the family, lost all that money. Had they contacted me many years earlier, we could have actually preserved all that money.
Wow.
Yep.
So John, for someone trying to decide whether to plan early or wait until care is imminent, how does timing affect what options are available for them?
I think for my typical client, the timing is not that big of a deal because we have so many things we can do here in Florida. In other states, I think it might be much more important, but here in Florida, and that $3.7 million example, the spouse was already in the nursing facility when I was hired, and we still got Medicaid within 30 to 60 days. So I think we don't have to do a lot of pre-planning here in Florida. There are some strategies that can be used. Two that I can think of. One is called a 5-year asset protection trust. So if you transfer assets to an irrevocable trust and then wait 5 years, that gets those assets out of the estate and they're not a concern for Medicaid. Another thing is that sometimes if somebody either doesn't have a homestead or a very inexpensive homestead, since we've got the $752,000 asset limit, the person, if they're still living in the community, can buy a new homestead property and shelter a huge amount of money that way. So let's say they have $800,000, they buy a $700,000 house, they only have $100,000 to shelter. So, but the person actually has to live in the house in order for it to be exempt. There was an attorney I heard tried to advise the client to purchase a homestead property. The client was already in the nursing facility. Client never lived there, and the state of Florida determined that it was a countable asset, the homestead, because the client never lived there and therefore did not have the intent to return to that property. So I thought that was an interesting fact pattern.
Absolutely. John, thank you so much for your time.
Sure.
Right. That's it for today's episode of Ask an Attorney, Florida Elder Law and Medicaid Planning. If you have questions about protecting your asset while qualifying for Medicaid in Florida, you can visit estatelegalplanning.com to explore free resources and schedule a consultation with John. Thanks for listening, and don't forget to like, subscribe, and share this episode with someone who might need it as well. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.